Hello, everyone. Thank you for joining us. Apologies, we were having some technical difficulties as we were getting started, but we will be getting started here shortly if you'll just bear with me. Wonderful. Can anyone give me a hands up or a comment to just let me know you guys can hear me? Yay, thank you. All right, let me get Michelle added in. Again, I apologize. There was some technical difficulties with a laptop, so I apologize for the delay here, but we are going to get started really soon. Thank you again for your patience. Michelle is now on her way. Excited to have everyone here. Today, we're going to be reviewing the Divorce Foundations, a one-on-one guide to Washington state family laws and what to expect. I have Michelle Dellino with us here, and she's our CEO and founding attorney of Dellino Family Law Group, and we're very excited to have you guys with us. I will hand it over to you, Michelle.
Great. Hi, I'm Michelle. Thanks for being here today. I am going to take you through a Divorce Foundation series. So one thing to know is that I'm an attorney, but I'm not your attorney. So I'm going to talk about some basics in Washington family law, what to expect in going through a divorce in Washington, and what those legal issues are. We're also going to take some questions. Anything I say should not be considered legal advice to you because we don't have an attorney-client relationship. This is a place for you to come and get information, so I'm going to give you information, but it's just that it's legal information, not legal advice. If you want legal advice, you should schedule a consultation with the attorney of your choice to discuss your individual situation. So with that said, we are going to talk about divorce in Washington, which is probably why you're all here. Things to know, okay? What I like to do when I really start thinking about where people are starting is talk about the basics. Who can file for divorce in Washington? There is a residency requirement. So we always start with talking about this because it comes up a lot. At least one spouse must reside in Washington at the time of filing. Washington's interesting because there's no minimum residency period, meaning a spouse can file immediately after moving to the state and establishing residency. You don't have to live here for a certain number of months. However, if one spouse doesn't live in Washington, you're going to need to talk to an attorney to understand if there's actually jurisdiction over the other party, the property, kids, all of that. I also like to talk about what jurisdiction means. What does that mean? That is a word that you might hear a lot during your divorce, depending on the situation. Jurisdiction means the ability of the court to actually make orders as it pertains to another party. So what does that mean? It means if the court's going to make you do something and there's going to be an order that says your kids have to live with this parent or they have to live here or your assets have to be divided a certain way. If it's going to impact another person, there has to be jurisdiction over that party. So the Washington court can't enter anything over a party unless there is jurisdiction. It's important for you to know that. On the basics of that note, I like to talk about kids for a minute. If you have children and one party's moving or you just moved here, there are certain laws that fall under the UCCJEA. That is a big acronym for the Uniform Child Custody Jurisdiction Enforcement Act. You don't need to know that or remember it. Here's the takeaway you do need to know. Wherever your children have resided for the last 6 months is known as the home state of the children. So if you just moved to Washington and your kids just got here, this is not their home state yet. It doesn't mean that Washington, you guys can't both consent to jurisdiction here if the whole family moved here, but it's not the home state yet. If you're moving to a new state, and you haven't been there for 6 months with your kids, this might still be the home state. So there's special rules that do apply to kids, which is different than someone just moving to Washington and filing for divorce. Okay, so that's basics. Another basic is the grounds for divorce. Washington is what is called a no-fault state, which means you don't have to prove there is a fault, that somebody did something to get a divorce. Anybody can get a divorce that wants to. The only thing that's required is to say that the marriage is irretrievably broken, and that is just one person doesn't want to be married anymore. So you can't force somebody to stay married to you. And you don't need to prove wrongdoing like abuse, adultery, financial exploitation, or spending. You don't need to do anything to prove that. You just need to claim the marriage is irretrievably broken. So anybody can get a divorce in Washington that wants to. There's no need to prove fault. Then there is a waiting period. So in Washington, there is a mandatory 90-day waiting period after filing before a divorce can be finalized. So this allows time for negotiation or reconciliation. In a situation like this, the reality is 90 days is a very fast divorce. You might think, oh my gosh, like I don't want to wait 3 months to be divorced. But any case where you're negotiating finance, custody, figuring out what's what to go through that process, 90 days is very short. A more realistic timeline that I like to give people is thinking about it like this. If you were to file for a divorce in King County, let's say, you're going to get a case schedule at the beginning of your case. And that case schedule is going to say that there's a number of benchmarks and procedural dates along the way. It's going to give you a trial date that's a year from when you file. And it's going to give you a deadline for mediation that's probably 10 to 11 months from when you file. Okay. And that should just tell you that a lot of cases, it's anticipated it would take that long to get to a trial, probably longer. The average timeline for a case where you're negotiating things, even in a cooperative sense, is generally, I'd say on the short end, 6 months, more realistically, 9 to 12, sometimes longer if it's a contentious case, so there's complicated issues or you're going to a trial. So 90 days is really fast, but there is a 90-day waiting period. If there are disputes over things, like I said, the process is going to take a lot longer. So that's something for you to think about. A lot of people have the mentality of like, I just want this done. Totally understand that. People don't love divorce. Even if you want to be getting divorced, you want it over with. If you are finding this to be a very painful process, which it is for most people, the most natural human response is, I want this over. But the fastest result is definitely not usually the best result. And you need to do your due diligence because this is a major life change. So I tell people divorce is far more of a marathon than it is a sprint. There's going to be a lot of different stages that you need to go through, and doing that it's just going to take time. So setting the expectation for that, I think, is very important. There are four main issues in a divorce in Washington that are going to need to be resolved. And then there are collateral or ancillary issues that kind of come from those issues. So I'm going to tell you what the big four are. If you don't have children, really only two of them apply to you. The first one is asset and debt division. No matter what it is, all assets and debts need to be divided. So Washington's community property state, and many assets and debts both are divided between both spouses. So we can talk about that in a few minutes. And in Washington, that division of property, if you take nothing else away from this, we are not a 50-50 state. I talk to people every day that seem to think that all assets and debts are going to be divided 50-50 because this is a community property state. Wrong, not true. Some states that are community property is divided 50-50 no matter what. That's not the case here. We are what's called a just and equitable state, which means a Washington court wants to know more about your marriage. The two most important things when learning to divide, when thinking about what's going to be done in dividing your community, are how long is your marriage, what's the length of the marriage, and what is the financial situation and the age of the parties at the time you're getting divorced. Are you retirement age? Are you younger? Is one party a stay-at-home spouse and the other party is the breadwinner? Is somebody need to get back into the workforce? Do you make the same amount of money? Like, what's your financial situation? What's your financial outlook at that point as far as education and jobs go? And how long you've been married? You might see a community property division of 60-40. You might see 55-45. You might even see 75-25. I don't know. It depends on the facts of your case. A lot of people also don't understand that Washington, in some ways, is what I would call a choose your own divorce adventure state. My friend Kim says that, and it's very true. What that means is you can structure your settlement however you want. Over 90% of family law cases are not going to end up in a trial. So you're going to get to be part of what that resolution is. And what that looks like is really going to depend based on your own individual situation. Part of it is going to be the asset and debt division. The other part of it is going to be spousal maintenance. That's the second issue in every case. It doesn't mean there's going to be spousal maintenance in every case, but what it means is you're going to have a situation that you're looking at to determine, is there going to be spousal maintenance? It's going to be yes, or it's going to be no. And if it is yes, then it's going to be figuring out what that looks like. And so that's a whole other analysis. So division of debts and assets and spousal maintenance are the first two. The third one is a parenting plan. Any divorce with children, if you have children, any divorce with children is going to require a parenting plan to be entered. So what that's going to look like, and that can take time to figure that out. So, you know, in a situation like this, you might have a temporary plan and then you might have a final plan. And if you have a temporary plan, sometimes that's going to become your final plan, or sometimes there's going to need to be a custody evaluation to figure out what's going to need to change or what's going to happen. So parenting plans. Parenting plans are entered in what is the best interest of the children, not necessarily what's best for the parents. So you could be like, oh, I want this plan. It's way more convenient for me. And the question isn't going to be what's convenient for you. It's going to be what's better for the age developmentally of your children and what's better for them. Parenting plans outline some major things. One, the residential schedule. Everybody knows you got to tell your kid, you got to tell the court where your kids are going to live when. Number two, decision-making authority. Who's going to make decisions about extracurricular activities, so on and so forth. And number three, dispute resolution methods. So those are three really big important things. If you guys don't agree, what dispute resolution method are you going to take? Other things that go into a parenting plan, holiday schedules, transportation arrangements, all kinds of extra provisions as well can be in there. But a parenting plan is going to have to happen. The last thing is going to be child support. Every time that there's children involved, there needs to be a child support order. Even if you and the other party are in a situation where you're agreeing that there's not going to be child support, that's not necessarily a given, and you still need an order because you need to determine who's going to pay insurance for the kids, who's going to be ordered to do that, how extracurricular and out-of-pocket issues are going to be resolved, and so on and so forth. So the way that child support works is usually the last thing that we do in a family law case, in a divorce, because it's dependent on other factors. It's dependent on who's receiving the support. We need to know what the parenting plan is first to know that. Is there maintenance? Because maintenance counts as income for one party and it gets debited from the other party for figuring out support obligations. Those things need to be figured out before we know what the child support is going to be. So that's the last piece of it. So there's really those four issues, and I'll talk about those four issues in a little more detail. But before I do, I want to see if there's any questions. So if you have any, the best thing you can do if you've been on these webinars before is you can drop them into the chat, and they'll go to Gabriella and she will go ahead and get back to you, or you can direct message her. I think the way that we have it set up is, well, I'm not sure, but generally there's a way to message her if you don't want everyone to see it. If not, and you want to drop it into the chat, you can do that. If you don't have any questions, that's totally fine too. We usually have a lot and I'm not seeing any, so I will keep going.
Sounds
Oh,
good, Michelle. I'm here, and yeah, just wanted to interject just a tad bit that I did put a message. Okay, it looks like some people are starting to flow in now.
okay.
But yes, you can use that Q&A for us to get started. The first one I have up is, how does substance abuse come into the equation?
It's a great question. Substance abuse, domestic violence, things like that, they come into the equation in a couple ways. One is the parenting plan. I'm going to talk about that. And the other is, like I said, there are other kind of collateral things that might happen in some cases. Domestic violence, protection orders, and protection orders are another way that sometimes it can come up. So the first thing that you should know is, if there is substance abuse, a lot of people have substance abuse issues. It is not going to be an issue in your parenting plan unless there's a nexus between that substance abuse and parenting. So if you have someone who had a substance abuse problem, they went to treatment and they're fine and there's no issues with their parenting, then it's not an issue. If you have somebody who might have a drinking problem, but they don't drink around the kids, it's never affected their parenting, you can't show a nexus between that and parenting, it's probably going to be harder for you to prove an issue. However, if you have an issue where there are genuine concerns about a parent's substance use, and it's a problem. Parenting plans, like I mentioned, have what's called residential provisions. So, generally speaking, both parents will have ample time with the kids and make decisions unless there's a reason not to. There is a section at the beginning of the parenting plan that deals with what we call restrictions. Substance abuse can be a basis for restrictions, as can domestic violence, other kinds of abuse, neglect. Um, Abandonment, all of those things, including substance abuse or mental health issues where there's a nexus to parenting, can be a basis for restrictions in a plan. So you might have a plan where someone has supervised visits for a period of time while they're doing treatment, or where someone can't have alcohol around a child, or where someone may be mandated to actually get an alcohol evaluation and do treatment before they're able to be in a place where they have overnights. It really is a very fact-specific thing that's going to depend on your own individual situation. But substance abuse can be a basis for restrictions in a parenting plan. They're called 191 restrictions, if you ever hear that term. It means those restrictions that may be in a parenting plan that may limit the time and decision making and other factors with your child. So that's definitely important. Great question. Any other questions?
Okay, let's see. I've got another one that says, what should you bring to, oh, so sorry, skipped one. Is there child support after the child turns 18, or what happens if there are children over the age of 18?
Yeah, great question. Is there child support? No, there's not child support, but there is post-secondary support that can happen. So child support order ends, and here's when it ends. It ends when a child turns 18 or graduates from high school, whichever is later. Because some people will have kids and they'll turn 18 in the middle of senior year. Well, child support goes all the way until the last day of high school. So, or 18, whichever is later. However, your child support order will have a clear section that addresses post-secondary support. Most of the time, post-secondary support in your order is going to be reserved unless your kids or child are really close to 18 or graduating from high school. Then you might come up with what it's going to be. The reason why is because you don't necessarily know, like if you have a 5-year-old or something, you don't know what your financial situation is going to be when the time comes, and you don't know what your child's plans are going to be, what kind of, post-secondary education they're going to be looking at, anything. You don't know anything yet. So when to move for post-secondary support, either party can seek post-secondary support, and they have to do it again by the time a child turns 18 or graduates from high school, whichever is later. So yes, there can be support, but it is post-secondary support. If you're negotiating a divorce and you have kids that are already in college, you might choose to address post-secondary as like how you're going to do it. And sometimes it'll be sometimes parties will have 529 accounts, and it'll be, hey, the 529 accounts are going to be exhausted, and then the parties will pay proportionally. Sometimes it'll be an agreement that the children pay part of it or take loans. It's going to depend on your family resources, your situation, what was contemplated, and so on and so forth. Sometimes cost of attendance might be capped. Sometimes we'll cap cost of attendance for future support at cost of attendance for University of Washington or a state school, and then people can go above and beyond that. But the end of the day, post-secondary support is a possibility, but it needs to be moved forward timely, and it does need to be addressed in your support order, but that is usually reserving it until later, till you know more what's going on.
Wonderful. And then I have a couple more questions and then we can keep it going.
Great.
It says, excuse me, assets and debts value is assigned at the start of the divorce filing or end of the divorce
Assets and debts value.
value.
Here's the thing for you to know. Both. It depends. A lot of things are going to factor to based on largely based on the length of your marriage. Like if you're in a long-term marriage, it's not really going to matter what separate property. All property is before the court in any case. So the court's going to know who has how much separate and community property. So like if you establish a date of separation, that's when your community stops, right? So if somebody files for divorce and you guys are separating and you don't get divorced for 2 years later, everything after you filed is separate property. So in most cases. So you might be using data separation for splitting up values, right? You might be doing that. But the court is still going to know if somebody earned a bunch of money or got a bunch of money post-separation, that is going to be taken into consideration when we think about a just and equitable division. So in a long term, and this is a lot of stuff too that you really should talk to an attorney about, because I'm going to say a lot of things and it's the language that I speak, but it's not the language that you speak. So you've never heard it before and you might be like, what did she say? If you're feeling that way, you should talk to somebody. So anyway, long story short is data separation. Those values are very often used. Yes. And that establishes the end of the community. However, there are other factors like the length of your marriage and what's really accumulated after that and valuing those assets and separating the value of a 401k before and after data separation. There's a lot of factors to consider. Sometimes we just use current values if it isn't that long. Sometimes we use data separation. Sometimes there's a valuation that's done for some of the assets and not for others. A home is always valued in real time at like what it is at the time you're valuing it. So there's a lot of different rules. But yes, it does establish an end of the community when a divorce is filed or the parties separate. So long answer, a lot of variables. So there's not really a hard and fast answer to that. But good question. I could
And then
take
I,
more.
okay, yeah. So I have one that says, is it possible to file for divorce if you are currently a stay-at-home mom, and what would that look like?
Yeah, a lot of stay-at-home moms file for divorce. You're not stuck in a marriage just because you're not working. One thing you'll need to know is that the court will see you at a certain point as voluntarily un or underemployed. You'll need to go back to work at a certain point. But if the status quo has been you haven't been working and you've been out of the workforce for a really long time, no one's going to expect you to go out and have an income and get a job right away. You're going to need spousal maintenance, and that's where, assuming that you have the need and the other party has the ability to pay, and given the facts of your case, it's very possible that you'll need spousal maintenance. So yes, you could file, and that's where we talk about the different issues in your case. What's the division of debts and assets going to look like? Well, in a just and equitable state, usually the financially disadvantaged spouse, which is very often a stay-at-home spouse, is going to recover less fast from a divorce, so they might take more of the community. So that might be one thing to know, okay? And the second thing to know is spousal support. And very often in cases, there will be what is called temporary orders. So you're like, what does that look like? Well, if you're filing for divorce, you're going to need a new normal. You're going to need some temporary support while the divorce plays out, while you negotiate things. You might need temporary spousal maintenance, temporary parenting plan, temporary child support. You also might need assistance paying your attorney fees. In Washington, fees can be paid based on need and ability to pay. So if you have the need and you don't have access to money, and the other party has the ability to pay, they may end up paying, all or some of your fees, or you may have the community paying some of your fees. But yes, you can file for divorce. Either party can. And I think in the case of a stay-at-home spouse, you're probably going to want to establish some temporary spousal maintenance while the case is pending. So I hope that helps.
Thank
And
you.
maybe one more before I move on. Anything else?
Sounds good. It said, what should I bring to my consultation with a lawyer, such as financial information, etc.?
Yeah, I wouldn't really bring anything because a consultation isn't going to give you all the answers that you want. Most lawyers, if you're going to a consultation, are going to send you an intake ahead of time to give you a basic outline. Like I did consultations just this morning, and what I do is like, yeah, it's helpful for me to have some information, but I'm not going to get into your finances and tell you what's what and be looking at your spreadsheet or building out a spreadsheet for you in a consultation. Consultation is a time to talk about, like I said, these four main issues and how that might apply to your situation. You're going to need to come. It's helpful for me to know ahead of time. Do you have a house or real estate? Do you have retirement accounts? Do you have 401ks? Like, what do you have, right? What do you have that's helpful? Just like a general idea. And some parties have no idea because they have no visibility into the finances. But I want to hear when someone comes to meet with me, what's the story of your marriage? Did you work? Were you a stay-at-home spouse? What's your education? What's the situation with your kids? How do you guys handle things now? I want to get to know you, and I want to get to know what your situation might be so I can think about the issues in your case and what might be possible resolutions or things that you should know as you start to prepare. So don't worry about like, I got to download my bank statements and bring all of that. You're going to need that. Absolutely. But for a consultation, just the basics, knowing where you stand, who's living in the house, what your goals are for the divorce. It's more of a big picture conversation. So hopefully that alleviates some of the stress about what to bring. I think people do worry about that. So great question. Really helpful to a lot of people, I think.
Thank you,
So
Michelle.
I want to talk about, just to make sure I'm hitting on everything here for you. I talked a little bit about asset and debt division and how we're a just and equitable state and how there might be what we call a disproportionate division. I want to touch back on that for a minute, and I want to talk about how in a short-term marriage, what happens in a short-term marriage is, Washington treats the length of marriage as a major factor. So I want to talk about that in case people listening are at different stages and they want to know this. So in a short-term marriage, you're dealing with a situation where that's usually 5 years or less, okay? Like 5 years or less, maybe six, but generally it's speaking, it's 5 years or less. nobody, the way the court sees it is that nobody in a short-term marriage has really relied on the community long enough to really be walking away with a lot more than the other person. So typically parties are looking to, it's backward looking. We're looking back at where people started. We're trying to put them back where they started. Nobody's really being enriched by the marriage. You're probably dividing assets and debts pretty close to 50-50. Maybe a little more, a little less either way if somebody makes a lot more or there's something unique about the situation. And maybe there's a little temporary support, but not much. That's a short-term marriage. Most marriages fall into the midterm marriage bucket. So there's shorter midterm marriages, 6 or 7 years, on up to midterm marriages that are 22, 23 years. Okay. Big range. Most divorces happen in there. In those situations, depending on how long you've been married, the idea is that asset and debt division is trying to leave people on somewhat more of an equal footing as they exit the marriage. So one person then maybe who's not making as much can rehabilitate themselves. You might see a stay-at-home spouse exiting a 16-year marriage, exiting a midterm marriage with 55 or 60% of the assets and spousal support. That would not be unreasonable. But it also depends on the individual financial situations that your family is in. So midterm marriages, that's where we see a lot more negotiation, a lot more variance. It's usually a situation where you're dealing with asset and debt division, maybe maintenance, maybe not. So, and then there's long-term marriages. In Washington, case law defines long-term marriages as 25 years or more. There is a principle of equality in long-term marriages, and there's also essentially lifestyle maintenance. There's no lifestyle maintenance in shorter marriages, which means people aren't entitled to maintain the same lifestyle they had in the marriage. There's no entitlement to that. That's why I said, nobody's relied on the marriage long enough in a short-term marriage. In a midterm marriage, maybe for a while, but it ends. In a long-term marriage, there's an expectation that the parties will essentially be on equal footing forever. So it's a question then of how many working years are left, what is the situation, and what does it look like? Okay. So at this point, you know, you're married that long. If you don't have working years left, you're pretty much dividing up what you have somewhat equally. And then there's factors and considerations when you think about Social Security, pensions, other things like that. So that might be what happens. It also could be a situation where if there's not a lot of resources, but somebody is still working and maybe they have 10 working years left, it could be a division of assets plus maintenance. Or even if they do have assets, you don't want to leave somebody with one working spouse with a lot of years left and the other person not working in a long-term marriage, which can happen if you get married young, because then one person is it's not going to be equal. One person's going to out-earn the other person for a period of time. So then there might be spousal maintenance. So really thinking about, is it a short-term, a midterm, or a long-term marriage is very much going to help inform the property division. So that's important for you to know. The other thing I want to talk about is spousal maintenance a little bit more. So what is it? Some states call it alimony. We call it spousal maintenance or spousal support here. And it is a post-divorce payment from one payment to the other for support. That's what it is. It can also be happening on a temporary basis, like I mentioned earlier, during the divorce, while the divorce is going on. So there's a general rule of thumb. We don't have a statutory calculation in Washington, but we do have case law and we have some guidelines, and we do have a statute that talks about when maintenance should be awarded. But there's no, like, I plug in this income and it gives me a formula. There's none of that. It really is what courts have called in Washington a quote unquote flexible tool to do equity. And equity is to make things fair. I don't like to use the word fair. There's one, I think it's going on with Puyallup. That's a fair. I promise you, if we're talking about what's fair, what I think is fair would not be what my spouse thinks is fair. So just forget about that word. Think about the word as equitable. Maintenance can be used to do equity, to create an equity between the parties. Asset and debt division, equity. Don't think about what's fair because that's not going to seem the same to anybody. So in Washington, if there is spousal maintenance, the rule of thumb is generally every 3 to 4 years of marriage equals 1 year of post-divorce maintenance. So I like to think in broad terms. Think about a 12-year marriage, okay? That would be between 3 and 4 years of post-divorce support if maintenance was appropriate. If the parties make about the same amount of money, or if one party can't afford to pay maintenance and the other party just needs to work or whatever, there might not be maintenance. It really depends. But if there is 3 to 4 years of maintenance, of marriage, is usually 1 year of post-divorce maintenance. Another common question I get is, what if I pay temporary support for a year while the divorce is going on? Is that going to count towards my post-divorce support? In most cases, no. So that's something else for you to know. So that's a little bit more about spousal maintenance. I can talk a little more about parenting plans, but first I'll check if there's any questions about either of those two sections or anything else. Do we have any, Gabby?
Yeah, sorry, I was on
Oh, you're
mute.
fine. No worries.
Yeah, so I had someone who said that they are retired due to health issues, related to cancer. And so when it comes to insurance through their spouse, is it required coverage or does that impact spousal maintenance?
Say that again. Say that one more time. I want to
No
make sure
worries.
that you're right.
Yeah, so it looks like the couple has been married for 11 years,
Okay.
and one of them is now retired due to health-related issues with cancer.
Okay.
They have their health insurance through their spouse.
Hmm.
Is
Ah, okay.
coverage with insurance included in spousal maintenance? How does that impact that? Do they still get coverage?
That's a great question. And a lot of the time, it's a really good question. This comes up a lot. So, a couple things to know. While your divorce is going on, if you're covered by your spouse's insurance, you're not going to be taken off. You can't be taken off. Typically, it'll depend on the employee's plan, whoever's carrying the maintenance, but it'll either usually be the last day. It's usually the last day of the month that your divorce is final. So let's say you got your divorce finalized December 10th, you'd be off on December 31 would be your last day. Okay. So some people will agree, like if a spouse has medical procedures coming up or whatever, some people will agree not to finalize the case for a period of time to keep someone on benefits. You might come to a full settlement that's binding that you're operating under, but you might not finalize for a period of time. If at a certain point, though, you're going to need to get your own coverage. So when you do that, that's an important thing to think about. What'll happen as part of your case and part of spousal maintenance is you'll do what's called a financial declaration, which is really showing kind of like what it's going to cost for you to sustain yourself and your life post-divorce, right? Like post-separation, really. Like what's it going to cost? How much are my expenses going to be? And medical insurance is going to be factored in. So you might need to be in a situation where you're doing some research ahead of time and figuring out if I'm not going to be working, what's the plan going to look like for me on the marketplace? How much is that going to cost? That kind of a thing. Other alternatives, which doesn't work in every case, so I want to put this out there, is sometimes people will negotiate to do a legal separation. Legal separation does all the things. Divides assets, awards maintenance if it applies, does a parenting plan, does child support, but you're legally married at the end of the case. So, and then either party can convert that later to a divorce after 6 months of finalization. But some people will do a legal separation because some employers will allow you, even after finalizing a legal separation, to keep another spouse on benefits. Some will not because it recognizes that you're then financially independent. So sometimes that's an option. But to answer your question, yes, it factors in and it would be part of figuring out what your needs are and what that's going to cost. So I hope that's helpful.
Wonderful, thank you. I have a couple of more that are related more so towards child support, parenting plan, and a prenup question.
Okay, I'll take the prenup question and the child support one, and then I'll talk about parenting and I'll answer that one.
Okay, sounds good. It says, does a prenup protect only assets for prior to the marriage?
Depends on how good your prenup is and what it covers. A good prenup is forward looking. Here's the thing to know too. Smart people do prenups, but a lot of people that are really smart don't have them. And the reason why is because I think there used to be a certain stigma that prenups were bad or they were only for people with money or whatever. And now it's a lot more of a thing that people are doing. So if you don't have one, it probably would have saved you time and money, but you probably didn't know to have one and it wasn't a common thing. Now it's becoming more and more common. I can't tell you enough, even if you think I have nothing. A prenup shouldn't be about what you bring into the marriage or what you had. It's about what you're going to establish and grow during the marriage, as well as what you bring in, which for a lot of people isn't a lot. But anyway, I'm a big believer in prenuptial agreements, and I'm someone that has litigated a lot of divorces, so I can tell you, a very solid and well thought out prenup is a good thing for you because it's going to save you tens of thousands, even maybe hundreds of thousands of dollars of divorce in a divorce if you have a complicated divorce financially. It's also good for marriages, I think, because it gives the parties an opportunity to have hard discussions about finances early on. I mean, a prenup is kind of like, I think about it like car insurance. Like, I don't carry a lot of liability on car insurance because I'm planning on hitting someone. I hope I never need it. But if I do, I don't want it to financially decimate me. And I don't recommend that you have a prenup because you're planning on getting divorced and you want to save money on your divorce. But if you do, it won't financially decimate you or your spouse. A prenup, I think, is a show of love and trust to the other party that we're going to decide what the terms are if our marriage ends, not the state of Washington. And we're not going to spend a ton of money tearing each other down in the process. So to answer your question, a prenup depends on how well it's written. It depends on if it's valid. A lot of people have prenups out there that are not valid, that don't meet a Washington test for validity, and depends on if it addresses what if it addresses all the necessary things. It should be forward looking. It should talk about how income is going to be treated during a marriage, retirement. It should talk about what you're bringing in. It should talk about the separate property that you either have or will have. And there's a lot of things. So a prenup is a very good thing, but it can also be a complicated thing, and you should get somebody that understands them to do it for you. So I hope that's helpful.
Awesome. Thank you, Michelle. And then the one that was related to child support says, does child support impact spousal maintenance?
That's a great question. It can. So like, for example, I settled a case not that long ago. That's a great example of this. Party A is paying spousal maintenance to party B, but party B would owe child support to party A because party A is going to be the primary parent. So party A's spousal support obligation to party B is reduced by the amount of money that party B would be paying to party A, because it doesn't make sense for them to each just be exchanging checks. So yes, that can be a factor. Absolutely. It just depends on what it looks like. On the other hand, you could have somebody getting spousal maintenance and child support. The other thing to think about is when you do child support, we do have a statutory formula for child support. There's a calculator that basically we look at what income is, and we look at age of your child or children, and we have a number based on that. And then it's allocated pro rata between who makes how much of that number, basically. So if one party makes 75% of the income, other party makes 25, it's a 75-25 split. And then the party that has more nights gets that part of the transfer payment. It makes a lot more sense when I show you on paper, I promise. But the thing to know is that if you're paying maintenance to somebody, that's reducing your income every month. And then that maintenance on the child support worksheet counts as income to them. So it absolutely does factor in, which is why I said earlier, child support's like the last thing we figure, because we have to know what the parenting plan is going to look like, and we have to know what spousal maintenance is going to look like before we can know what that child support calculation would accurately be. So I hope that makes sense.
Awesome. Thank you, Michelle. I'll let you
Yeah.
keep going and we can cover those parenting plan ones.
Yeah. Yeah. Okay. Yeah. Just a second. All right.
Of course.
Okay. I just wanted to make sure where I left off. All right. So I talked about division of debts and assets and spousal maintenance. Okay. So in addition to that, there's two other big issues, the parenting plan and the child support. What I want to make sure that you understand is what's reasonable in a parenting plan, the kinds of things you're going to be deciding. I touched on this a little bit earlier, but I'm going to talk about that in a minute. The next thing is child support. And I like to leave that for last because, like I said, it sounds weird, but it's a lot more minimum. Okay. So when we think about parenting plans, I mentioned this earlier, it's really about what's in the best interest of the child. It's not about necessarily what is more convenient for you. And a lot of parents don't understand the difference. They think, well, what's best for me is what's best for my child. And that might be true. But at the same time, when you're no longer in the same house and you're talking about dividing time between two houses, a lot of that's going to depend on like, how old are your children? It might be best for you to think, I want my kids like all the time, but it's also best for your child to have time with the other parent. If my child is super young and my child is, 0 to 5, like not quite yet school age, it's going to be really hard for my child to go more than a couple of days without seeing either parent. Like it's not good. And that's developmentally what people think, unless there's a reason. So you might think it's better for me to have my kid all the time. And the reasonable parenting plan might be, it's better for you guys to exchange every couple of days. So you are still, seeing the child frequently. So like, for example, an age appropriate parenting plan for a young child might be what we call a 2-2-3. So 2 days with one parent, 2 days with the other, and then 3 days with that first parent. And then it flips and it keeps going. So it's equal time. That's very different than a teenage child who doesn't need to see mom or dad or whoever the parents are like every couple of days to maintain that bond and to feel safe and secure. That kind of a plan might transition to being, hey, we exchange the kids every Monday at school and they're week on, week off if you're on an equal time plan. That's totally normal. When I started doing divorce a long time ago, it was really common to see every other weekend plans, because then conventional wisdom was a lot more that children should have one home base and then every other weekend they go and see the other parent. But developmentally, that position has changed now. So there is much more of a movement towards equal time unless there's a reason not to, which would be those restrictions that we talked about earlier. Or if it just logistically doesn't make sense. You can't have an equal time plan with schools and stuff if one parent lives in Everett and one lives in Tacoma. Like that's not realistic. So it's also also in considering where the parents live. And doesn't mean like one parent's good parent and one parent's bad parent. It means like what's logistically going to make sense and where do your kids go to school. If you want an equal parenting time plan, though, you really kind of do need to commit to living close together or at least being able to make school work in a way that's best for your kids. So what's best for you is not always best for your kids. It's really about what's best for them. Parenting plans not only have those residential schedules, but like I talked about earlier, they have holiday time. So they're going to talk about what looks good for holidays. How does that look? And I really think that's important. That's important for you to know because you're not going to want to be, oh man, it's Thanksgiving and I want to go see my family in California and I don't know if what day I'm getting the kids and when to buy plane tickets or any of that. So parenting plan helps alleviate that and deals with what those kinds of things should look like. It also can deal with like events that are special to a family. If every year you do this one thing on this one day and both parent parties want to alternate that, you can do that too. You can build in special holidays. It can also be other religious holidays, Jewish holidays, Indian holidays. Diwali is a popular one. Rosh Hashanah, Yom Kippur, Hanukkah, all kinds of different things can be decided because you don't want those to be coming up at the last minute and trying to figure out what's going on. There's two types of custody. We don't really use the term custody that much in Washington. There is joint custody and there is sole custody. So joint custody are when both parents share responsibility, okay? And that means basically most plans, you have physical custody under that joint custody, okay? Physical and legal custody. Physical custody is who has the child when. You both have it at different times, right? You both have time. You have physical custody when the kids are with you and you make decisions. So really that's a joint situation. Legal custody is who gets to be a legal parent, who gets to call the school and get information, who gets to make decisions for their child. Usually that's both people too. Okay. And then there's like a sole custody situation, which is very rare where one parent isn't in the picture at all or has no decision making and basically no residential time. That's hardly ever, and there needs to be a real basis for restrictions. So that's a little bit more about parenting. I think, Gabby, I think you said there is
Yeah.
parenting questions. I'm happy to answer that.
Yeah, it says, do children get a say in parenting plan when they reach a certain age?
No, people like to say at what age, people always ask me, at what age do children get a say? When they're 18, when they're adults. They don't get a say when they're children. So in some states, it'll be like, oh, when a child's 13, they get to say where they want to live. In Washington, that's a hard no. A court's never going to hear from your kids in Washington. However, I want to clarify that a little bit because if you're in a divorce or you're in a parenting plan modification and you have a custody evaluation, and that can factor in. Not every case is going to have one, but a lot of cases where parents don't agree or there's allegations about whatever, there might be a guardian ad litem whose job it is to do a report, or there might be a parenting evaluator, or there might be family court services. Somebody might do an evaluation. We could do a whole webinar just on the different types of evaluators. But anyway, someone does an evaluation. If you have a teenage child, they're going to talk to your child. And if your child is saying, oh, I want to live here or here, or I feel secure here and safe here and I don't here, your child, when they're older, they're able to verbalize and they're able to explain things a lot more. And an evaluator is also going to know, though, like, oh, does this parent just want to be at mom's because there's no rules at mom's? Or does this parent want to be at dad's because dad's never home? Like, they're going to have a clue, right? But if there are really specific concerns from a child, obviously those are going to factor in and the evaluator can take those into consideration. And they're usually going to do that a lot more when a child is older than when they're younger, because when they're younger, it could just be like, I want to be at mom's because that's where I get more treats. So like they don't have the same set of reasoning or ability to verbalize the way that an older child does. But there is no age and a child does not ever get to make the decision in Washington, even though their voice might come in through an evaluator. They're never going to be able to tell a court where they want to live. And it's really disfavored to bring your child into the litigation or to be asking them that. Most parenting plans will have a provision that says neither parent will ask a child, to have input on custody because that's seen as really detrimental. So before I take more questions, I want to touch on a few more things about child support and then I'll spend the rest of the time on questions. So
That's good.
just to make sure I cover everything on it. So child support, I touch on this a little bit. So there will be a formula based on the parent's income, number of children, how old they are, and then it will go from there, and it's a calculation. And we already talked about payments continuing until a child turns 18 or graduating from high school, and then it goes to post-secondary. I wanted to talk about, and a child support order, we also talked about how the insurance needs to be decided in there as well. I want to talk about, what about if things change? Like, what if you need to change your child support? Can you do that? That's a really good question that I get a lot. There's two ways to change your child support order. One, any party can seek an adjustment 24 months from the time the last order enters. What's an adjustment? It's literally just adjusting based on income. So, for example, if you have a different income in 24 months, or the other party does, and you want to adjust income based on, you want to adjust the transfer payment and what that calculation would be based on current income and that proportional share, you can do that every 24 months. Some people do it like clockwork. They adjust the child support every 24 months. Some people never do. It's not going to happen automatically unless you bring an adjustment. The other thing, though, and this is important for you to know, is that you can bring a child support modification at any time there's a substantial change in circumstances that wasn't contemplated at the time your order entered. You don't have to wait 24 months. If you lose your job and you can't pay child support, you might need a modification. So that's something for you to know. The other thing for you to know that I want to make sure and cover is what child support's intended to cover. It's basic life necessities. It is food, it is shelter, it is clothing, it is curricular activities. It's not anything extra. Extracurriculars, soccer, band, all those kinds of things, out-of-pocket medical like orthodontia, therapy, copays, all of those things. Work-related childcare is another really big one if you have young children. All of those things are decided on proportional share lines, not the child support transfer payment. It's that 75-25 or 50-50 I was talking about earlier. Who makes how much of the income? And then each party pays their proportional share. So a lot going on there with child support, but it's important for you to know there's different aspects of it. There's the transfer payment, and then there is the proportional share for out-of-pocket expenses. It's also possible to have no child support if people have equal time with the child and income is very similar. Parties can agree on a deviation to no support. Last thing that I will say that's important for you to know is you can come up with any financial settlement you want in your divorce as far as assets and debts and spousal maintenance. No problem. Really easy. Come up with any settlement you want. And the court's not going to care. You could give all your assets to one party. They don't care. That's up to you. You're an adult. However, the court will be the final word in signing off on any parenting plan or child support. If you have a deviation to no support, the court's going to want to know why, and they're going to need worksheets to support it. You always have to have child support worksheets anyway, but they're going to want to know, and they're going to have to take special care if there's no child support because there's a vested interest of the state and they want to make sure kids are taken care of. Same thing for parenting plans. If there is a basis for restrictions, they're going to want to really look at that parenting plan closely. They're going to look at the plan closely for parenting plan or child support, and the court is the final word and can decline to enter a plan unless they know why or there's a sufficient basis. So that's important for you to know. We don't have a ton of time left, but I'm happy to take what other questions there are.
Yeah, of course. So I have one that says, does a stay-at-home parent with young children typically get to keep the home?
No, no, nobody typically gets to keep the home. That's going to be a very fact-specific analysis. You might get to stay in the home like while the divorce is pending, but if the question is going to be, can you afford to keep the home? Is there enough money that there are other assets to equalize the other party, or is the home going to have to be sold? If the home's the primary asset and there's not enough other assets, then one party can't stay in it because the other party has no way to get equalized. Sometimes parties will stay in a home and they'll stay there longer because there's kids in the home and they might agree to sell the home later or whatever. So there's times that can happen, but you can't lock up somebody's equity in the house unless there's money to equalize. And it's not necessarily going to be the stay-at-home parent. There is a real movement that both parties get to be parents, even if one person always stayed home. So, I mean, there's no guarantee that you're going to get to keep the home. You're either going to need spousal maintenance to qualify to keep the home, and you're going to need to go back to work. But the other thing is it really just depends on the specifics of your financial situation to know if the parties can afford for one party to keep the home. A lot of the time they can't. So, and if you can, great, but then it might be at what value are you keeping the home? What's the appraised value? Does somebody else have a competing appraisal? What's the financing situation? There's a lot of factors to figure in. But when you say typically, the answer to that is no.
Thank you. And then I have one that says, are children's birthdays considered holidays?
No. And I'm going to tell you this too. No one likes to hear this. Some people will want to put the children's birthdays in a parenting plan and they alternate the birthdays. That's really, I mean, you can do that, but the court's not ever going to do that. If you ended up in a court and they had to make a decision, they're going to tell you the common thing is that parents will celebrate the child's birthday when they have them. So that's normally what it is. Some people will want to get really micro about it. They want the child's birthday in there. They want their birthdays in there. Like you can do that. If it's a special thing to you that you really are, it's important for you guys to alternate that date, you can do it. But most people don't, honestly, because it creates then a disruption to, it falls on a different day every year. Is it a school day? Is it a non-school day? Is it in the middle of my summer break? Like it creates kind of chaos. So usually parents just celebrate it when they have the child. If it's important to you and you want to do it, you can. But I'm telling you, if one parent doesn't want to alternate it every other year, you're probably going to end up not doing that.
Okay. And then I have one person who's asked, we have multiple condos and assets, and we already know how we want to distribute those. Is that going to speed up the timeline when we file?
No. I mean, it might speed up your settlement, but like it has nothing to do with like when you file or what. You can finalize your divorce anytime after 90 days. A lot of people will have a full settlement when they file even like that's fine, but it's not going to like change like the court's process if that's what you're asking. It'll help if you come in with an idea of like, hey, I want these properties, they want those properties. You're going to have to agree on values and those are going to have to be equitable, and you're going to have to look at your full picture and come to a full settlement on who's getting what percentage of the assets. If I'm keeping a condo that's worth $1 million and you're keeping one that's worth 700,000, where's the equalization coming from? Or what does that look like? Or is one party getting more? Is one party getting less? What are the other pieces of it? It is true that if you guys generally know what you want, that can be really helpful. But then one person can think they know what they want, and then they can realize that's totally unfair and they should be getting more and change their minds. I have people all the time that are like, we know what we want. And then they look at it and they're like, oh no, I don't want this. So you never know. But the more that you can cooperate when coming to a settlement, the faster and easier your process is going to be, but it's not going to like change court deadlines or anything. So
Perfect. And then my last question is going to be, excuse me, how do expenses for college children or college tuition happen when the child is over 18?
that's going to be your post-secondary support that we talked about earlier. It's going to depend on the individual situation. It's going to depend on how much income the parents have. It's going to depend on what the cost of attendance is, what your child's contribution is going to be, if any. Are there 529 accounts? Are there anything like that? It's going to depend on all of that. So it is addressed though in post-secondary. So you do have an opportunity to address it. So
Wonderful. Thank you so much to everyone being here. I have some stay in touch information for Michelle. You're always welcome to book a consultation with us on our website or by giving us a call. We have a large team ready to take additional answers. And Michelle, if there's anything else you want to close out with.
no, I was just gonna say you guys asked a lot of great questions. Feel free to we do a couple things. We do these series every month. We do a foundation series like this to just talk about the basics. I usually do a special topics every month as well. So there'll be one of those as well. I think that's coming up this month. I don't know, Gabby, maybe you can check and see or when it is, but we do one special topics and we do one foundations every month. We also do a meetup group that you guys should know about. It's called the Do's and Don'ts of Separation and Divorce. You can link to it off of our website and it's on meetup.com. So we usually meet for that the last Wednesday of every month. This year, this September, I think we're doing it actually in person on Wednesday, September 17. Usually it's virtual, but once a quarter or two, we do them in person in Bellevue. And that's a time that if you want, you can come. We'll buy you some food and answer your questions in person, and people get a chance to chat. That can be a very nice thing. Otherwise, we do it every month, usually the last Wednesday of the month, online. So if you want another chance to ask questions, hear other people's questions, and be part of that community, please feel free. And then, of course, like Gabriella said, feel free to book a consultation if you want. And even if it's not with me or our firm, I highly, highly recommend that you schedule, between 1 and 3 consultations. Talk to a few attorneys. Yeah, it's a cost and it's an investment, but it's important that you're working with somebody and a firm that you feel like aligned with and that you feel like is a good fit for your situation. So it also gives you a really good idea about what to expect in your case. You get an idea, and you want to come away from that with a framework. So I really hope that that was helpful. Again, thanks for coming. Even if you didn't ask questions and you just listened, it's great that you were here. And if you did ask questions, your questions probably help more people than just you. So thank you so much. Have a nice day and we'll see you next time. Bye-bye.
And then anyone still in the chat, excuse me, I have dropped down a couple of links there for our upcoming webinars. We are going to be doing one later this month, the day after, so it'll be September 18th, that we do one regarding high conflict divorce. So I've dropped the link in our group chat, and I've also put a link to our meetup group so you can RSVP if you would like to be in person with us or see our upcoming virtual options as well. Thank you so much for being here. I'm going to leave the chat and the webinar open for just a couple of more minutes so everybody has time to get that link. Thank you. I hope everyone has a great day.